Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello, everyone, and welcome to this Federalist Society virtual event. My name is Sarah Clark, and I'm Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum called SAP, Motorola, and the Future of PTAB Reform. We're very pleased to welcome our moderator, Philip Nelson, who is a partner at Knopf Martens. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we will turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I will note, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Mr. Nelson, thank you so much for joining us today, and I'll hand things over to you.
Thank you very much, Sarah. This is Philip Nelson, sitting here in my office in Knopf Martens on the West Coast, and I have the privilege of introducing our topic and our three distinguished panelists. We're going to hear today from Jamie Simpson, who is a Chief Policy Officer and Counsel for the Council for Innovation Promotion, C4IP, which is a bipartisan coalition dedicated to promoting strong and effective intellectual property rights that drive innovation, boost economic competitiveness, and improve lives. And we also have Arthur Gollwitzer, partner at Jackson Walker LLP. He combines experience gained as a federal prosecutor with over 25 years in private practice to represent clients in patent, copyright, trademark, and trade secret disputes, including jury trials and appeals. And our third panelist is Robert Taylor, founder and owner of RPT Legal Strategies in San Francisco and Palo Alto. It provides legal and business advice to companies and investors with respect to all aspects of intellectual property and related fields. So to start off, I'm going to give you a little premise, historical view that the panelists may agree or disagree with, but I'll just put it out there that in at least the last decade, judges deciding patent-related cases have tended to disfavor patents and patent holders in disputes more than in previous decades, especially at the Supreme Court, I would argue, in the Federal Circuit. In many cases, legal considerations may have been set aside in favor of policy considerations. And the current Patent Office, PTO leadership appears to be reacting to this somewhat anti-patent approach, using its discretion to mostly deny patent validity challenges. So that's the context. We'll see if the panelists agree with that. But we'll use three recent legal developments to discuss this topic. Two are Federal Circuit mandamus petitions, the SAP and Motorola petitions. They challenge the Patent Office's actions. And the third is a recent open letter to the public from the new PTO Director John Squires. And I'll just give you a little more background before I turn it over to Jamie. The Patent Trial and Appeal Board at the U.S. Patent and Trademark Office has been a source of extensive policy and legal debate since the America Invents Act created this administrative tribunal in 2012. The Supreme Court has wrestled with several PTAB procedures and decisions, and the PTAB reform bills have been introduced in every Congress since 2017, not yet passed, but introduced. A main role of this body, the PTAB, is to decide IPR petitions that challenge the validity of issued patents. This year, the new PTO leadership has drastically reduced the success rate of these petitions, preserving validity of the underlying patents, which are often being asserted in patent infringement litigation in a separate proceeding. First, the PTO acting director, Coke Morgan Stewart, began exercising discretionary denial authority, and it's available to her under the AIA to deny IPR petitions at a much higher rate than ever before. This process began quite abruptly in the spring of this year, 2025. One of her main rationales for this change has relied on the age of the challenged patent. where patents 6 years or older give rise to settled expectations of validity. This doctrine had not previously been relied on in the IPR context. Second, whereas after the discretionary denial stage, 3-judge panels of PTAB judges were previously tasked to decide whether to institute the IPR, newly confirmed PTO Director John Squires has just announced last week that he will now make this decision instead of the 3-judge panel. So PTAB judges will only review the merits of an IPR petition after it has survived both the discretionary denial and institution thresholds. Both of those are being decided by PTO leadership. So the PTO argues the director has unreviewable discretion to deny IPR petitions. It cites 35 USC 314, which states that the PTO director, quote, may not authorize an IPR unless he or she, quote, determines that the petition has a reasonable likelihood of success. The statute further states that the director, quote, shall determine whether to institute an IPR under certain timing constraints. Finally, the statute provides that, quote, the determination of the director whether to institute an inter partes review under this section shall be final and non-appealable. The Supreme Court generally upheld the non-appealability of the PTO's institution decisions in the Cuozzo case, which is in 2016. That limited APA challenges and allowed PTO discretion. The Supreme Court reserved judicial review for cases where the PTO might engage in shenanigans, such as violating the Constitution or exceeding statutory authority. So SAP, the cases we're discussing today, and Motorola, in those cases, 2 companies whose IPR petitions were denied filed mandamus petitions with the Federal Circuit challenging the PTO's approach. SAP argues that the PTO's new approach violated due process by occurring too abruptly and applying retroactively. It also argues that this settled expectations standard, or the 6-year age of the patent standard I mentioned before, is new and unfair. Motorola mostly focuses on the retroactive effect of the new approach. So both SAP and Motorola argue that the PTO's recent approach amounts to shenanigans effectively, so this is why they are attempting to appeal. Even more recently, the PTO has now formally proposed new rules requiring petitioners to waive future prior art challenges to qualify for IPR institution. We may get into that a little more. So, question for the panelists. We'll go first with Jamie. Assuming that we all want strong but also high quality patents, is the PTO proceeding in a wise manner to achieve its goals? Go ahead. I'm going to turn the time to Jamie now.
All right. Well, thank you, Philip, for setting that up so well. And thank you to the Federalist Society for inviting me here today. This is, I would say, a great issue that crystallizes a number of things that have been percolating in the patent space and in the IPR space for over a dozen years now. And I thought it was interesting in Philip's remarks that he talked about the PTAB being created to have these IPR disputes. And of course, we all know that PTAB was created to do much more than that. This is actually only just one of its functions. It's supposed to also decide post-grant proceedings, which are, or post-grant reviews, which are authorized right after a patent issues before IPRs are allowed. It also handles ex parte appeals. It also handles derivation procedures. And I think it says a lot about where we are today that the PTAB is virtually synonymous with IPRs. And I think that is indeed where all of our focus has been, but I'm not really sure that this is what was intended when the statute was passed. So taking a step back, I really look at these mandamus petitions as posing a fundamental question, which is, do petitioners have a right to agency review of a patent? They refer to a lot of procedural complaints, especially in the earlier mandamus petitions, which have kind of evolved over time. But at bottom, what they're saying is that essentially they have a right to have a patent reviewed before the PTAB after it's been issued. And I think ever since the PTAB was created and started hearing these appeals, you have heard patent owners raise a lot of concerns with this idea that there's sort of of an unfettered right to agency review and re-review and re-review of a patent. And certainly when I was on the Hill before my current job, I heard a lot of these concerns. And I think over time, the agency has responded to them in a number of ways, culminating in where we are now, where you're kind of seeing this war of trying to find a balance between those who want an unfettered right to review before the PTAB and those who are the patent owners who really need quiet title to their patent. And that has a lot of knock-on effects, particularly whether or not a patent can function as it was originally intended to do in order to promote further research and development and commercialization of an idea. So what I want to just touch on very briefly before turning it to my other panelists is what exactly these mandamus petitions crystallize. So to me, they crystallize three major issues. And Philip touched on the first one, which is what does this discretion of the director really mean? So far, the courts seem to have suggested that the language of the statute is interpreted as saying that the director has unfettered discretion to deny, can only institute if certain statutory criteria are met. And I think what we're seeing right now is a director and a deputy director who've kind of taken that to a certain extreme and said that they feel for a number of reasons that they're going to exercise their discretion in a way that is a lot more robust than previous directors have done. And that brings me to the second point, which is that even if the director has this much discretion, what procedures govern how they can exercise that discretion? So we saw the initial actions from this administration come out in a series of memos. And those memos were reversing memos that came out under the previous administration. So to me, in some ways, this is kind of a war of different memos, none of which went through the formal notice and comment rulemaking procedures that the APA requires. It's not clear if that is required in this circumstance, although that is what some of the petitioners in these mandamus petitions argue. And that kind of brings me to the third point, which is that I think we can see with these memos, regardless on what side of the line you might fall on in terms of whether or not these are good policy, is if you believe in the patent system, there's something troubling by having the validity and the procedures governing these 20-year-long rights in some cases be changed by a memo without any further procedure. And I wonder if this is really a function of having agency or having adjudication located in the executive branch instead of district courts. And that was a major policy decision that was made in the AIA, which we've seen play out over the past dozen plus years. And I think it might have played out a little differently than Congress intended, given the intervening Arthrex decision from the Supreme Court that gave a lot more power to the director than Congress envisioned when it passed the AIA. But now we're seeing what happens when you have adjudication be ultimately controlled, as the Supreme Court has directed, by a politically accountable executive branch official. And you're seeing that this means that there will be changes between administrations. And in effect, in some ways, in this context, you're electing who your adjudicator is in the person who is nominated as the director. And I would submit that we would all be better off under these circumstances if we took a hard look at some of these decision points that I've just kind of mentioned that I think have been crystallized and pass laws addressing them so that these decisions are settled and there is not so much room for maneuvering between administrations. One bill that does that, that is pending before Congress right now is the Prevail Act, and we can talk about that more if it comes up. But I think this would settle a lot of these outstanding questions and help eliminate the seesaw, which I think is ultimately to the detriment of the patent system. So I'm sorry, I've probably talked more than my allotted time, but I will stop here and turn it over to my co-panelists.
That sounds good. Thank you, Jamie. And we're going to go with Art next, but Jamie's made some interesting points. And I'm just going to introduce one thought, which is that in the oil states case, I think Justice Gorsuch's dissent may have presaged some of this political back and forth that we're seeing now. So I'm going to get Jamie and Art's thoughts on that in a minute. But Art, why don't you take the floor?
Sure. Thank you. Thank you for having me on the panel, and thanks for the introduction and setting the stage. It sounds like we have a lot of common ground here, right? I think we all believe in the importance of the patent system in protecting and incentivizing innovation. I think we all believe, it seems like, that predictability and reliability are sort of hallmarks of a stable legal system in total, really. I mean, we can focus on patents here today, but for people need to be able to rely on the laws, and people need to know that when we make a business decision or you make a strategic decision, that the rules aren't going to change in the middle of the game. So with that said, when we get to the premise of, or the question is have the patent office's recent actions been wise? Have they been lawful? Are they a good idea? However you want to phrase it. I think the answer is no. We can get to the goal and maybe a universal goal of a strong and predictable and reliable patent system. But I suggest that this isn't the way to do it. We live, let's start with an almost, an undebatable premise, although, sometimes today I'm never sure about that. But we live in a constitutional republic, right? And one of the defining features of a constitutional republic is that we're governed by the rule of law. And that's in contrast with the rule of any one person. And as much as that sounds like common sense, that was a pretty significant departure from most of human history at the founding of our country. And that means that the rules aren't set by a single person, an unelected person, in this case, even an interim director who wasn't confirmed yet by the Senate. We have introduced in the past 6 months a new procedure of denying IPRs. Okay, right? And IPRs are an administrative way to challenge the validity of a patent, created by Congress, as we've heard, under the America Invents Act 12-ish years ago. And it sounds like Jamie and I might debate the merits of the America Invents Act and whether it went too far, but it was a law passed by Congress and signed by the president. And if we don't like the law, we should change the law. So IPRs were created under the AIA. And in the past 6 months, the Patent Office has decided that there's going to be an extra step in this process, right? It's going to entertain motions for discretionary denial of these challenges based on a set of criteria that were created out of whole cloth, right? They aren't found in the statutes. They aren't found in the case law. And in a constitutional republic, I don't think we do that. We don't change the rules in the middle. And I should add, this is all happening in the middle of the game, so to speak. I mean, when you look at the Motorola petition for mandamus, and I think SAP to a certain extent, but especially Motorola, they were dealing with IPRs that had been instituted under the director's authority, right? There was a likelihood of success on the merits. And those institution decisions were reversed under this new policy. That's changing the rules of the game. It's not, and I think most, children on a schoolyard would agree that you can't change the rules of the game in the middle of the game. That's not fair. We changed the rules with new legislation, or in the agency sphere. Agencies can set new rules by posting them publicly, inviting public comment, taking that comment into account, and issuing rules that fit within its statutory authority. And of course, then if they don't, there's legal challenges and whatnot. And I'll throw in one more twist, which is in the real world is very important to clients. I mean, very practical. The filing fee for an IPR petition is at least $50,000. There's some room for movement, but it's roughly $50,000. You don't even get your money back, right? You get half of it back, right? So the government is keeping half of a $50,000 filing fee after the director decides, as a matter of discretion, not on the merits, discretion, not to allow that IPR to go forward. That just seems fundamentally unfair in a constitutional republic. There was, I think Jamie mentioned the director may have more power than Congress envisioned. And if that is the case, then we need to change the law. We don't want this seesaw as she described. I agree. And this current movement is so far to one extreme that it's the constitutional challenges to what is happening are very appealing. That this is it's fundamentally unfair. It's also it's fundamentally unconservative, right? This is not how a constitutional republic is supposed to work. So I'll stop there and pass it along to Robert, and I'm sure we'll have a lot more to say about all this.
Before I pass to Robert, Art, when we come back to you, I wanted you to respond to a couple thoughts that occurred to me as you were talking. You mentioned that that's an unelected person, which may be true with Director Stewart, but it's still the political branch. So I want you to respond to whether or not it's okay to have somebody who's appointed by an elected person making some of these decisions. And then the other question I wanted to ask you was, whether the AIA does provide discretion to the director, or at least to the PTO. So whether that is arguably not changing the rules in the middle of the game after all. But let me turn the time over to Robert to see what he has to respond to you and any further questions for the other panelists. Go ahead, Robert.
Let me make the observation in response to Art as to whether the patent system is governed by a rule of law. I think anyone who has watched the Supreme Court over the last 15 years abolish hundreds or thousands of issued property rights with the stroke of a single sentence in an opinion would seriously question whether the basic principles of a constitutional republic actually govern the way that court approaches patent law. With respect to something that a couple of the prior speakers have said, is that this started 10 or 12 years ago. This actually started in 2006, 19 years ago, when the Supreme Court abolished a presumptive right to obtain an injunction to enforce what is heralded as an exclusive right. And the court really never came to grips with what the term exclusive, or how you fit the term exclusive together with what they were ruling. But that is, be that as it may, Justice Roberts had a very powerful concurring opinion saying in the vast majority of patent cases over the last 200 years, finding of infringement and validity was sufficient for the court to issue an injunction. All that having been said, let me talk about the things that I was planning to say on my own, and then we can come back to some of the other points. First of all, I am the general counsel of USIJ, the Alliance of U.S. Startups and Inventors for Jobs. It is a small alliance made up of inventors, entrepreneurs, startup companies, and investors who fund these operations, and all of these entities that form USIJ and its support base are absolutely reliant on the property right in a patent in order to raise money, to justify spending years of commitment to a new technology. And increasingly, the weaknesses in the patent system are causing this group of this USIJ cohort to diminish, and that is really unfortunate, because I believe, and if you read the brief that USIJ filed in the SAP case, I have a couple of paragraphs and a very powerful footnote talking about the fact that it's not large companies that create real disruptive innovation. It's small companies, individual inventors, and that has always been true. And you can find case after case after case demonstrating it. You can read the USIJ brief and get some cites to that, but it's an often told story. There's another point that we make in the brief is that mandamus is not the right way for this issue to be delivered to the courts. Mandamus petitions are for extraordinary situations. There's nothing extraordinary about telling a company like SAP or Motorola, go to the district court. You can still invalidate patents in the district court, like you have been able to do for 225 years before the PTAB came along. The PTAB was put in place not for the benefit of patent owners, but for the benefit of people who are challenged with infringement of patents. And the size and scope of the door to get into that arena is left to the discretion of the patent office. And this case really does involve the question of whether Congress meant what it said when it put the no appeal from institution decisions provision in Section 314. The court in Cuozzo said that Congress meant that and intended it. They have some difficulty with the lack of precision in the IPR provision of the act itself, but there's no ambiguity in what the Supreme Court said is the director's discretion to deny institution in the judgment of the director. And there's just no appeal from that. And if there was any doubt about it after the Cuozzo case, the court said exactly the same thing again in the Thrive case, and made clear that this just is not something that is subject to appeal, and all this mandamus petition route is just a disguised form of trying to get around the no appeal provision. Philip raised the question of settled expectations and talked about whether the court can, or whether the PTAB can use settled expectations as a criteria for whether to institute. The PTAB is given virtually unlimited discretion by the statute in terms of how an IPR proceeding can or should be structured. One of the things we bring out in the USIJ brief is that when Congress enacted the provisions in the IPR provision, there was a real concern on the part of Congress that it was going to be used to harass small companies and individual inventors, and a number of the senators expressed it. I quoted in the USIJ brief. We quote, by the way, Meredith Addy was a co-author of that brief. I signed it, but she was a co-author, and what we cited was some language that to the effect that sort of lost my train of thought there. I was talking about. I'll move on. Settled expectations. The patent office has every ability to do this. Has every rationale for establishing the scope of the PTAB review. It was established initially by a director, Michelle Lee, who came to the patent office from Google, and it was very heavily oriented towards finding patents invalid. We now have a director that doesn't want to be oriented towards finding patents invalid, or quite the same level of or same rate that it was occurring previously, and so they're putting in place the same type of provisions that have been the discretion of the director since the outset. I once again call attention to the fact that settled expectations are a fundamental aspect of property rights. Netlist, if you followed the Netlist versus Samsung case, you know that Netlist was issued a patent filed in 2007, and here we are in 2025, and that patent has been in examination or re-examination or IPR, or IPR re-exams since the day it was issued. And it's still there. Google was the first major force challenging the patent. And that went to the Federal Circuit, and the Federal Circuit upheld the validity of at least one claim. And then Samsung, Google's supplier for the same product, the accused product, filed an IPR request, and that got to a different IPR panel and was granted. And that's in front of the Federal Circuit right now. This is a case where by the time this case really is resolved, that patent will have been in this process for the entirety of its issued life. Congress did not intend that. And this is what hopefully this new director can put a stop to. And I've talked enough. Somebody else should pick up the cudgel.
Thank you, Bob. And when we come back to you, I just have a quick thought I want you to respond to, if you don't mind. But on the settled expectations question, the fact that people have been able to attack patents like the one you just described for the last many years means that may be the settled expectation of at least the public, is that you can attack patents. It may be, like you say, kind of a bad thing from a policy perspective. But I think the question many people have about the settled expectation standards is that, ironically, it may be a change to start relying on this, at least in the IPR context. So be thinking about that for when we come back to you. But Jamie, I'm going to have you go next to respond to anything Art brought up, and then we can do another round here. Jamie, go ahead.
Thanks. Yeah, I'd like to respond, hopefully briefly, to one of the points that Arthur raised about the unfairness of what is going on. And I'm going to say this in the context of some of the legal arguments that were brought up in the mandamus petitions. And what you hear some of the petitioners arguing is that this is unfair because they had a right to an IPR if they filed a certain type of stipulation called a soteris stipulation based on the earlier Vidal memo. So they frame this as a constitutional violation based on what they characterize as a liberty So anyway, they're claiming that their liberty interest was deprived without due process based on this memo. And this kind of goes back to the war of memos that I was talking about. So to me, I think, first of all, I think it's questionable whether or not a memo without even formal notice and comment rulemaking can give rise to a liberty interest. Just like that memo was issued one day, it could have been rescinded one day. And in fact, it was rescinded under the next acting director. So, I have questions about that just on that kind of that narrow legal point. But then I think kind of from a broader context, what you're saying, if you agree with the petitioners in this case, is that after an election, the new acting director and then the new director had to be controlled for a certain amount of time by the guidance issued by the previous director on how she wanted to exercise her discretion. And I guess I find it very questionable if the statute gives the director discretion, which I think is the best reading of the case law, that a future director needs to be constrained in that way by a previous director. It's a different question if you've gone through notice and comment rulemaking. But I think on this kind of narrow issue of memos, I think memos are in effect for as long as they're in effect. And I don't think they can give rise to something as substantial as a liberty interest. And, maybe you can go back and say the real problem is that someone should have sued to get the Vidal memo rescinded. And maybe that's true. Maybe that's where we'll come out. But anyway, I wanted to address that question, and I'll leave it there for the moment. Art,
do you want to respond to anything you've heard?
I'd like to respond to a lot, but I don't want to take up all of our time. I want to get to the questions you posed a few moments ago, but maybe I'll start with where I agree with Jamie. Right, I agree. The war of memos is bad public policy. I'd hope we all could agree with that. I mean, Robert, you mentioned settled expectations. I think we all want a stable patent system. We all want to respect property rights. I think we all believe that, again, you have to know go back to my childhood analogy, you have to know the rules of the game to make intelligent business decisions. So we agree there. I think implicit in that, I think I heard it from maybe both Jamie and Robert, or at least one of them, that there's no right to an IPR. And I agree with that as well, right? And this is going to dovetail into, Philip, your questions. The statute, the AIA, gave the director power over the institution decision. The director has a bit of a gatekeeper function by law. So I agree there's no right to an IPR. Now, where we may differ is on what bases can the director decide whether or not an IPR can go forward? And while everyone while we were all discussing, I went to the language of the statute itself, right? This is what we do in a nation governed by law. And under Section 314 of the America Invents Act, it says the director determines that the information presented in the petition, and it cites the response petition, that there is a reasonable likelihood that the petitioner would prevail with respect to at least one of the claims challenged. That's the standard set forth in 314. And then actually in Section 316, Congress directed the Patent Office to establish regulations, meaning through the notice and comment process, for exercising the power in 314. So that never happened, right? I think so we're left with 314. I mean, maybe we say shame on Congress for delegating too much power to an agency without enough guidance. I think that's a criticism a lot of us may have of a lot of congressional action, but this is what we have. And in 314, the director determines whether or not to institute based on this reasonable likelihood of prevailing. Well, that is very different than what we see in the most recent memo, but in the memos being promulgated by the interim director and the current director, because the discretionary denial, its very name, it's called discretionary denial, is not about the merits. It's about, and they've delineated factors that are found nowhere in the statute, nowhere in the case law about.
Oh, could I jump in? Because I mean, I think I don't want to. Sorry to jump in, but the wording of the statute here is very important. But it says the director may not authorize institution unless, right? So it's really turns on this word unless, right? So obviously you need to meet that substantive standard that you're talking about, but it's how much weight do you put on the unless part, and that's where all the discretion comes from.
So let's keep talking. Fair enough, but let's talk about that discretion. Robert talked about and following the rule of law, and I think he challenged some of my opening statements. But the AIA, the American Invents Act, the thing that created the IPR and gave all this work to the PTAB, was created by Congress. It's the law. All three of us might agree it has flaws, but we fix flaws in the law by passing new laws. So, even if the director had some discretion beyond the merits, what we've seen in the past 6 to 8 months is a set of criteria that did not exist 6 months ago, settled expectations and whatnot. And I'd love to address settled expectations down the road here. But right now, we sit in a position where I have pulled some numbers. As of Sunday, something like, let's see if I can find it quickly. I think we were up to, it was in the hundreds of petitions have been rejected. 900 patent owner DDRs have been filed, 900 motions for discretionary denial. 61% of them have been discretionarily denied. This is according to a website that's tracking all of these things. 61% of IPRs thrown out in the past 6 months based on these criteria that interim director Stewart set forth. At what point does the exercise of discretion become just an abrogation of the law? Right? So even if you could do this, if we're rejecting 2/3 of all petitions, 2/3 of these petitioners who are doing what Congress said they can do are being thrown out, not on the merits, but on these other criteria. If that's not enough, what if it's 90%? What if it's 99%? At what point, and this is the problem with this open-ended discretionary, the idea that each director and each administration can do what they want, you literally can abrogate the law, right? There will be no IPRs if the director, based on discretion, is disposing of 2/3, 90, 99, 99.9%. And again, I'll remind everyone, when that happens, the applicant doesn't even get his filing fee back, which I know it sounds like a little thing, but to a real client in the real world, that's awful. And if I think back to my days as an assistant U.S. attorney, I'd call that fraud. I mean, if I contract with someone, if I send you $50,000 for a service and you decide, you know what, we're not going to perform that service. We're not going to evaluate this patent. And oh, by the way, I'm going to keep half your money. That's not right. That can't be appropriate. So, and I think, Philip, you asked a question about both discretion and does it matter that whether it's an interim director or a presidentially appointed and confirmed by the Senate director? I do think that matters, right? I mean, we have an executive branch. The agencies have been empowered to do things. And if a director has been formally nominated and approved, as long as he or she is acting within their statutory authority, and as long as something like discretion isn't turning into a complete abrogation of a statutory right, then sure, the actions of the confirmed director, I think, carry more weight. But my argument, I still stand by my argument that what we're seeing here is a rejection of IPR petitions based on criteria found nowhere in the law. And one of them, which again, hopefully I'll have time to allow me to comment on in a minute, settled expectations seems to be the one that is taking up all the oxygen in the room, right? And many of these denials are based on what is being called settled expectations. This is a doctrine, and that did not exist and has no authority in the statute or in the case law.
Go ahead, Robert. Go ahead, Robert.
A couple of points, Art. First of all, the fairness of this procedure starts with the fact that an applicant for patent spends thousands upon thousands of dollars, maybe more than 50, maybe more than 100, to get the patent issued, and then to have it turn around and have the same agency that collected that $100,000 say to the patent or collected a large part of that, say to the patent owner, well, your property right is nullified, and you're just out all that money and all the expectations that go with for your investors trying to fund a project that was designed to develop a product. The other part of this is talking about the question of settled expectations. It seems to me that is implicit in virtually all business transactions. You want some reliability as to what your rights mean, and you can't build businesses. And it's the reason more and more investors and companies are not trying to build businesses around their patent portfolios because they don't trust them. A patent is only valuable if people believe in it. And if people do stop believing in it, then it doesn't matter whether it's enforceable or not. If you don't believe in it, you're not going to use it.
May I quickly respond to that? The fairness, again, I feel like we are putting two things on an equal playing field when they're not. Yeah, absolutely. Inventors spend thousands of dollars obtaining patents. My colleagues right next door prosecute patents for people. We represent plaintiffs in patent cases. I'm not anti-patent. I believe we need a strong patent system. It encourages innovation. That investment is important. And though a patent is issued by going through the procedures with the patent office and many criteria are met, a patent is issued, and I'm oversimplifying things. But at the same time, Congress created the America Invents Act, which created a pathway to challenging those patents. Now, I understand if one or two or all three of us don't agree with everything in the AIA, but it's the law. So to say, well, I don't like that law because it created a pathway to invalidate a patent that my client paid for, so I'm going to support a director making up new policy out of whole cloth because I don't like the AIA, that is incongruous to me, right? If you don't like the AIA, either a court finds it unconstitutional, which has not happened, or we go to Congress, and I think one or both of you mentioned the Prevail Act. Maybe that's the way to go. I'm not the expert on the Prevail Act, but it has to be done legislatively, not by fiat, because again, rule of law over rule of man.
Yeah, I guess the one thing I would say, in response to that, is that, yes, obviously Congress created the AIA, but they created it by giving the director a lot of discretion to implement it. And I think the justifications at the time were that the director would be in a better position to make changes to adjust for circumstances that might be unforeseen that come up. And, I think that's what we've seen over time, different rulemaking packages, different changes. And that kind of goes back to my point that I think some of this is about how the changes are made. And it obviously the mandamus petitions are about what sort of notice is due and when is something retroactive and when is it not. And I think we probably do all differ and how we come out in some of those questions. But, I don't think you can say that this is all against the AIAs. I think the AIA explicitly gave the director a lot of discretion and a lot of rulemaking authority.
So I wanted to ask one thing before we go to maybe closing commentary, but Art, does it make you feel any better about the way this is unfolded that the newly confirmed director, Squires, appears to have endorsed what interim director or Koch Morgan Stewart had been doing before, because he allowed her to continue in this role of deciding the discretionary denial decisions. And then he I think, implied in this new memo recently that he was going to continue following basically the framework she had established of settled expectations. Does that make you feel any better about the fact that this may be approved by someone who is confirmed by Congress?
Yeah, I mean, marginally better, right? As I said, the director has been confirmed by the Senate and has statutory authority to put it simply, run the patent office, right? But, and Jamie's right. I mean, there's discretion. I mean, it's that unless clause is written in the negative and the statute's focused on being a gatekeeper based on the merits, but there's room to argue there's some discretion there. But again, discretion has to have bounds. If discretion can be based on factors that nobody ever considered or that have no basis in law or case law or statute, I find that troubling. And if the new director, if Director Squires goes through the public notice and comment period, I suspect there will be such feedback. But at least going forward, let's say those rules are implemented, let's say they survive for future legislative challenges, at least then they're known going forward. If I may take this moment to address what I call the irony of settled expectations is, it's one thing to say, well, I have a patent, so there's this settled expectation that I can enforce it. Except we've always had, well, always might be too strong, at least back to what the 1952 Act, the doctrine of ex parte reexamination. So the idea of challenging a patent in the patent office is not new. The AIA created another vehicle, the inter partes review and the post-grant review, several they're related vehicles to challenge patents, again, created by law. So and then of course the district court. And so whether it takes 10 years to get to the Supreme Court or not, and whether we like the Supreme Court's rulings in cases like Alice, those all went through well-known settled processes for challenging patents, right? So we've never taken a patent as written on a stone tablet handed to Moses on Mount Sinai. It's a piece of paper issued by a government agency. And we all know what Ronald Reagan said about the government being here to help, right? The government makes mistakes all the time. So there's always been a process. The settled expectation has always been your process can be challenged. Now, to me, what's ironic about the current directors, the interim director and now the current director, relying so heavily on settled expectations to discretionarily deny, it is out of thin air. They've decided that the magic number is 6 or 7 years. If the patent being challenged is more than 6 or 7 years old, I couldn't get statistics on this, but it is highly likely. I mean, now we are pushing into the 90% range that this IPR petition will be rejected discretionarily, not on the merits. Who decided that 6 or 7 years was the magic number? And what does that say to a small business who there's a defendant in a patent suit, right? We want to protect small businesses. I think we all want to do that. But what about a small business that is a defendant that had no economic ability, expertise, or incentive to be tracking patents from the moment they were issued? Heck, they weren't even in the business at the time, right? The business, and you weren't around 6 years ago, and you find yourself faced with a patent suit, you pay your $50,000, and the director says, well, that patent's 7 years old, so I'm going to throw out your challenge. That is far from settled expectations, right? We had this legal vehicle for challenging this patent, and all of a sudden there is this hurdle you have to get over, and it's almost an absolute hurdle. There's very few exceptions. Or your petition will be denied and you won't get your money back. That's not fair.
I want to get Robert's reaction, but first I wanted just to point out, Art, that last week or a couple of weeks ago, I had a couple 12 or 13-year-old patents that were referred for decision on the merits by the PTAB. So maybe I am in the
you did a really good job pointing out examiner error, is my guess, right? So
that's what we relied on. But first, I want to get Robert's reaction to this. In the academic research, there's some. I think Adam Mossoff has pointed this out before, but in the Festo case that we probably all remember from a couple decades ago, they used the phrase settled expectations regarding patent rights. And so I think some argue that the concept of settled expectations is not new to the patent law, even if it may be new to this context. And so I want Robert to elaborate, if he would, a little bit on the point he made before. Then we'll go to closing statements. But I think Robert said that there is a bit of an inherent expectation of something settled about patent rights. Go ahead.
Well, the statute says that patents have the attributes of personal property. And we know from property law, there's always been something called adverse possession. Somebody squats on someone else's land for 5 years in open, notorious possession of that land, and others come along and believe that that's the owner, and then the true owner shows up maybe 6 or 7 years later. That piece of property went to the squatter, so that's an example of what settled expectations in property actually means. And these patents are just like property when you get into the commercial world. People would like to believe in them. We have had difficulty in recent years getting people to believe in them, but that's still the fundamental thesis of the patent system. And you asked a question earlier. We're running out of time here, I know, and I'll stop. But you asked a question earlier, is don't potential defendants have settled expectations because of the fact that the system has been allowing virtually anybody to come into the patent office and challenge the existence of a patent, even for people that had absolutely nothing resembling Article 3 standing. And the short answer is, if you read the statute and you read the patent law, read Title 35, you shouldn't have settled expectations that you have a right to dispense with that patent unless you've got something really valuable. And if you've got something really valuable in the nature of prior art, you always have your right in district court.
Okay, thank you, Robert. So brief closing comments, and then I think we'll wrap up. Jamie, do you want to go first?
Sure. Just picking up on something that Art said at the end, whether or not the acting director could change, her mind or have a memo. I would say if the acting director didn't have the authority to do that, then I question how, as acting director, she would have the authority to finalize any final written decisions that invalidate a patent. And that might point to a bigger problem in having these proceedings, again, in the executive branch. Implications we haven't thought through in the AIA that are still bubbling up to this day. And again, I think this kind of all points to the fact that a lot of these issues have percolated and now I would say have kind of crystallized. And I do think it's time for Congress to look at this again and with the benefit of hindsight, figure out how to make these work hopefully a little bit better.
Thank you. Art.
Yes, I'll keep it short as well. But to answer Jamie's last question, the director has the legal authority to run the patent office. When the director takes actions that essentially abrogate a congressional statute, I believe that's when the line is crossed. So the settled expectations are that patents are subject to challenge. Unlike a piece of personal property or a piece of real estate that we can touch, a patent is it's given by the patent office, and the patent office can make mistakes. And we've always, for 50, 60, 70 years, at least the 52 Act, we've had ex parte reexaminations where we can, anybody, don't need Article 3 standing, can request review of that patent on the merits. The America Invents Act created another path to question a patent, challenge a patent on the merits. If we don't like that, we should all get together and work on drafting new legislations. And in the meantime, I'd ask the directors, please refund the filing fees if you're going to deny based on discretion rather than the merits. That's only fair.
Thank you, Art. And don't forget about inter-partes re-exam. Those were around for a long time, too. Maybe not quite as long as ex-parte. All right, Robert, final comment.
I will endorse Arthur's request that the Patent Office refund the filing fees when they reject something by discretion. And that doesn't trouble me nearly as much as some of the other things that people have said. And with that, thank you very much for including me in this. It's been a really enjoyable exercise, and thanks to all of the participants, and particularly to the Federalist Society.
Thank you very much. We'll conclude there. Sarah?
On behalf of the Federalist Society, thank you so much to Art, Jamie, and Bob for speaking with us today, and for Philip for moderating. We're so grateful for your time and expertise on this important topic. Thank you to our audience for joining us. We really appreciate your participation. You can also stay up to date with other announcements and upcoming webinars on our website, fedsoc.org. We're on all major social media platforms. Thank you once more for tuning in, and we are adjourned.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federalist Society's practice groups. For more information about the Federalist Society, the practice groups, and to become a Federalist Society member, please visit our website at fedsoc.org.